For those who are unfamiliar with ethical culture, we are a humanist, congregationally based movement. We're about 150 years old, and we're dedicated to exploring the ways in which we can live meaningful and ethical lives. Unlike traditional religions, we have no supernatural component to our services, and we don't require belief or non-belief in a supreme or transcendental being or existence. Those questions are up to you personally and individually. Our motto is deed before creed, and we believe that how you act in life is more important than any creed that you might espouse. Our speaker this morning is Professor Eric Foner. I'm going to introduce him more fully later, but for now, suffice it to say that he's one of the premier historians and public intellectuals of our time. He is particularly, but not exclusively, focused on the Civil War and Reconstruction, and we're really honored to have him as our guest today. Before we go any further, I know we have a number of people who are not members today and who may be interested, or maybe came because they're mostly interested in the speaker, but we would like to hear from our membership committee. So if either Ed Gross or Ron Schwartz is here to make an announcement from the membership committee, please unmute yourself and go ahead.
Thanks, Dan. I'm Ron Schwartz. I'm co-chair of the membership committee. I want to welcome everybody to our Valentine's Day program. Happy Valentine's Day to everybody, especially newcomers. Welcome. And if any of you are interested in learning more about ethical culture, we're a very busy and active and progressive organization. You'll hear more about what we're doing at our announcements at the end of the platform. But if you're more interested in learning more about it, talking to me or Eddie, and you're interested maybe even in discussing membership or learning more about it, put it into the chat and I will be getting back to you. Anyway, have a good Sunday and happy Valentine's Day to everybody.
Thank you. So we do have music today. Len Goldstein will be giving us our music, but Eric Sandhusen will be introducing Len. Eric, take it away.
Great, thank you. Some of us, we may be remembering Chick Corea, who passed away this week, the jazz great, musical genius. One of the things that I heard quoted by him this week was, he said, he encouraged everyone to share their music. And he said, even if it's not for your own sake, do it for everyone else's sake, because the world needs more music. So I want to give some thanks to Len and to Alan for encouraging me and joining me with a little bit of fun in bringing out this maybe a Valentine's Day confection. This is a debut of an original song of mine. It's a love song for Valentine's Day, but one of the good things about it is there's no words to it. So it can be a love song for whatever or whoever is in your heart today. And hopefully it captures that feeling of love. So the name of it is It's a Beautiful World.
3, 4.
I hope you enjoyed that.
Thank you, Len and Eric and Alan. That was lovely, and gets us to a good start today. So let's get into the heart of today's conversation. Eric Foner is the DeWitt Clinton Professor Emeritus of History at Columbia University, and he's widely regarded as one of the premier historians of our time. His extensive publications have concentrated on the intersections of intellectual, political, and social history, and the history of American race relations, with a major focus on events leading up to, during, and after the Civil War. He was a nominee for the 1989 Pulitzer Prize in History for his book, Reconstruction, America's Unfinished Revolution, 1863 to 1877. And he won the 2011 Pulitzer Prize in History for, excuse me, The Fiery Trial, Abraham Lincoln and American Slavery. Among his many honors are election as a Fellow of the American Academy of Arts and Sciences, the British Academy, the American Philosophical Society, and the American Academy of Political and Social Science. His work, which ranges from scholarly treatises to curatorship of museum exhibitions, has been deeply influential among both professional historians and much of the general reading public. In addition to his leadership in history, he's also an outstanding public intellectual who frequently brings his historical acumen to bear on contemporary issues, writing in The Nation, on whose editorial board he serves, the New York Times, the Washington Post, and numerous other publications. So I'm really honored today to be interviewing Professor Foner, and the focus of our conversation today is his book, The Second Founding, holding that up for you right here, The Second Founding, How the Civil War and Reconstruction Remade the Constitution. And I highly recommend this, not just because I'm interviewing Eric Foner today. It's a very informative and valuable book. But let me make a recommendation. If you read the book, which, as I said, I recommend you do, the book has an appendix. And I would suggest that you read the appendix first, or at least after you've read the preface. And the reason is the appendix is a really valuable and succinct outline of the Reconstruction era and of the key issues addressed in the book. So unless you're already a specialist in the area, reading the appendix first will help to give you a background and framework for following the narrative of the book itself. So the book focuses on, in particular, the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, and how they deal with issues of rights and racial equality, and how in the process of doing that, they reframe the Constitution. And so my first question for Professor Foner, I want to get to a couple of points about things that happened before the Civil War. And later, we'll get to how some of these things applied. So, Professor Foner, you described in the book various separate categories of rights that were envisioned before the Civil War. You discuss unalienable rights, such as are enumerated in the Declaration of Independence, civil rights, political rights, and social rights. Can you unpack the differences among these rights and how those, we'll get into a little detail later, but on how those come into play, both the differences and the unification of those. But can you unpack some of the meanings of these different kinds of rights, especially as they were envisioned before the Civil War?
Yes, well, thank you, Dan, for having me here and moderating this discussion. Let me, though, say that in terms of my book, if the appendix is actually, you will not find the appendix if you get it through Amazon. The appendix, which is a brief history of Reconstruction, is only in Barnes and Noble books.
Ah, okay.
This is something arranged by my publisher. I didn't know anything about it until it was done. But in order to try to promote its sales, which of course I'm in favor of, Barnes and Noble, what it did was among my many works is a general textbook history of the United States, which is widely used in schools. They took the chapter on Reconstruction out of my textbook and put it in as the appendix. That's fine, as you say, it's a summary, a clear summary of the era, but don't walk into a bookstore unless it's Barnes and Noble and expect to get that particular edition or get it through Amazon. But anyway, that's I've learned a lot over the years about the publishing industry. And the one thing I definitely know is the author is the person with the least influence on what happens with a book. The publishers do it themselves, and this is how they decided to promote the book in part. All right. Yeah, the question is a good one. Before the Civil War, today, if you talk about rights, you're sort of talking about all sorts of different kinds of things. And in fact, the civil rights movement dealt with a lot of things which in previous generations were not actually considered civil rights, like the right to vote, for example. But before the Civil War, people who talked about this kind of thing were, they made this distinction. Number one, natural rights. Rights that everybody is entitled to by virtue of being human. In the Declaration of Independence, these are the unalienable rights of man: life, liberty, that's why slavery is wrong in the view of anti-slavery people, and the pursuit of happiness, which is a kind of amorphous concept. Abraham Lincoln talked a lot about it being sort of equivalent to having the right to improve your condition in life, to rise in the social scale, to enjoy the fruits of your labor. Everybody was entitled to that. That's another reason why slavery is wrong. It denies people the opportunity to advance in society. Those are inalienable rights. Nobody should be deprived of them, although many people were in this country as slaves. Then there were civil rights. Civil rights is sort of the rights that enable you to compete in the marketplace, the right to go to court, the right to own property, the right to sue and be sued, the right to testify in court. In other words, the rights that are needed to protect your legal standing as a citizen of the country. And then there are what are called political rights. That's not the same thing. The right to vote. That is not a natural right. And indeed, it's something that was denied to large numbers of people, as we know. Before the Civil War, women could not vote in any state except, I hope you're all well aware of this, New Jersey, widely known today for being at the cutting edge of all progressive thought. New Jersey allowed women to vote between 1776 and 1807, when they woke up and discovered some women were actually voting. So they put the word male into the state constitution, and not to be considered too forward-looking, they also put the word white in. So after 1807, only white men could vote in New Jersey, and indeed in most of the country. In other words, political rights could be regulated by the state governments. And people who could vote in Massachusetts couldn't vote if they moved into Ohio. Black people, for example, lost their right to vote if they moved from one state to another generally. So that's another category, political rights. And then there's this amorphous idea of social rights, which were considered personal contacts sort of outside the realm of government. Who you marry, who your friends are, who you invite to dinner. Social rights are not to be regulated by the state as these other ones could be. Now, this is it's easy for historians to lay this out and to say, all right, look here, this guy's talking about civil rights, this guy's talking about political rights. But even back then, before the Civil War, you know, if apart from lawyers, most people didn't really think this way. They wanted all these rights all together. They didn't make such a harsh, a hard and fast distinction. Certainly, African Americans who were denied many, if not most, of these rights in most of the country, they insisted on all of them. They said, no, we are entitled to exactly the same rights as white people, and we will not settle for anything less. And there were white abolitionists who, not that many of them, but who also insisted. And one of the things about the abolitionist movement before the war is they insisted that not only should slavery end, but that the 4 million emancipated slaves should enjoy all the rights that white people enjoy. That was not a very popular position. Indeed, most people who criticized slavery, of whom there were many, certainly didn't adhere to this idea of racial equality. Even Lincoln, before the Civil War, who deeply hated slavery, no question about it, yet he thought the ultimate solution was to encourage Black people to leave the country, go to Africa, go to Central America, go to Haiti. He could not conceive of the United States as a biracial society of equals. Although during the Civil War, Lincoln came closer and closer to that idea. His thinking evolved in very dramatic ways. After the war, in Reconstruction, this sharp distinction among rights pretty much dissolved, and people just talked about rights, the rights of man, the rights of citizens, the rights of Americans, and they kind of threw everything into the hopper. This was an era of what we call rights consciousness, where people were really debating, what does it mean to be a free American? What rights come with citizenship in the United States? And that was an important part of the politics on which Reconstruction turned.
Thanks. You've also addressed the next question I was going to ask. So, but I think that's an important part of the understanding, is that these legally viewed separate categories become unified. Concomitant with that, and actually again raised by exactly the point that you noted about how in New Jersey, women and before 1807, Black people actually could vote. And I guess you mentioned that in other states too, here and there, at least people who weren't white could vote earlier in the 19th century. And that raises the question of what was it that happened in the first third of the 19th century, maybe even the first 40 or 50 years of the 19th century, that actually closed the doors to Black people voting in those states. And we're talking well before the escalation that leads to the Civil War. And concomitant with that, do you have people besides African Americans, do you have white people basically already thinking as early as the late 18th and early 19th century that Black people are absolutely equal? In fact, that human beings are all of the same type, regardless of race or skin color. I seem to have recalled references to Tom Paine, perhaps thinking of that, and I know that's one of your areas of expertise. Yeah. I don't know how good those references are, but in general, did you start to have at least a few people, other than those on the receiving end of oppression, who were starting to conceive of people really as being fully equal and fully the same in terms of all the social and political entitlements, even, as I say, even before the Civil War and Reconstruction era? So it's twofold question. Is there at least a little bit of that imagination there? And what was it that closed the doors in the 1820s, 30s, 40s to those who could vote?
Right. Well, yeah, as you say, at the time, let us say the Constitution was ratified in 1787, 1788. Free Black people could vote in a majority of the 13 original states, including some of the southern ones like North Carolina and Maryland, this is slave states. However, before we throw our hat in the air, the fact is there were hardly any free blacks. Almost every black person was a slave when the revolution took part. And second of all, they had to meet the property qualification. The voting was, you know, a lot of white people couldn't vote either. Mm-hmm. And very few black people could meet the property qualification in different states. And even New Jersey, the women who could vote, they had to meet the property qualification. That excluded everybody but widows, because married women could not own property in their under their own name. So even these open door policies were much more restrictive. But what happens in the first half of the 19th century, you might say, is that race replaces class, which, along with gender, is the barrier to voting. In other words, white men by the 1830s can vote everywhere, whether they own property or not. The property qualification falls away. And yet, at the same time, black men lose the right to vote. New Jersey takes it away. Connecticut takes it away. Pennsylvania takes it away. Every state that enters the Union after 1800 limits the right to vote to white men, except for Maine, the one exception. By the time of the Civil War, black men could vote only in Massachusetts and a couple of other New England states, of which there were very few black people living there. Why? Why did that happen? Well, there's one word that explains it: slavery. Slavery became the dominant economic system of the United States, not just of the South. We sometimes push slavery off onto the South. The economy of the North was completely tied in to the slave South. Cotton was by far the most important export of the United States. It was the earner of foreign exchange. The richest people in the country were big Southern slave owners. Just about every president, from George Washington to the eve of the Civil War, was a Southern slave owner, and the ones who weren't Southern slave owners were totally sympathetic to Southern slave owners, like James Buchanan or Franklin Pierce. The two exceptions were the two Adamses, John Adams, John Quincy Adams. They didn't much like slavery, but most presidents, and the South controlled the Supreme Court, and the power of slavery spread racist ideology throughout the country. Racism became the explanation. How can you justify having slavery in a country that declares it's dedicated to liberty? What about those inalienable rights that we mentioned in the Declaration of Independence? Where are they? Well, racism becomes the explanation. Black people are inferior. Therefore, depriving them of these rights is not really a deprivation. They are like children. They're incapable of being mature, intelligent citizens. And saying that a child can't vote is not depriving that child of anything, because a child doesn't have the intellectual wherewithal to vote. Same thing with black people, according to racist ideology. And by the way, if black people became free, the economy would collapse. So we certainly don't want that to happen. We need that cotton every year to be exported to England and other places. So it's the growing power of slavery. One of the things that historians used to claim is that slavery was dying out. It would have just disappeared automatically. It's irrational. It's not really economically viable. The Civil War was therefore unnecessary. It got rid of something that was dying out anyway. This is completely false. Slavery was not dying out at all. Slavery was growing rapidly. It was more profitable than it had ever been, and it was bigger. There were more slaves in the United States in 1860 than at any other time in our history. There were more slaves in the United States than in the rest of the world, at least than the rest of the Western Hemisphere. Add up Brazil, the British West Indies, Cuba, you name it. They didn't have as many slaves altogether as the United States, the 4 million slaves here. it wasn't going anywhere, sadly. Now, the fact is, yes, the abolitionist movement was predicated on the equality of man. Now, not all of them fully acted on that, but the stated principles of the abolitionist movement were anti-racist, that not only should slavery be ended, but this should be a biracial society of equals. That's what alarmed a lot of people about the abolitionists. There were plenty of people who didn't like slavery in the North, who criticized it, who felt that the slave owners shouldn't be controlling the federal government, all sorts of things. But the number who believed in racial equality was much, much smaller. And you have to give your credit not only to the Black abolitionists, but to the William Lloyd Garrisons and Louis Tapans and Wendell Phillipses and others who challenged the whole ideology of racism. They challenged a kind of pseudo-history that that developed, which claimed that Black people in Africa had never produced any civilization, and this proved they were better off in the United States as slaves. So this is deeply, this is not just abstract ancient history. This is deeply embedded in the history of the United States. And even though slavery is gone, the legacy of slavery in belief in racial equality is still there in our DNA in some place, not every single person, but in many facets of our society.
Thanks for illuminating that. What I'd like to do now is briefly review the three Reconstruction Amendments, because these are the three, when we talk about the remaking of the Constitution, as you subtitled the book, these are the three amendments that do that. And I have specific questions about each. So what I'd like to do is just quickly review what each one says. I know them well, and I think many of us who are here know them well, but I think it'd still be valuable just to refresh our memories. And I have a couple of questions about each, and then I'll want to wind up with a couple of very general questions about the period. So first, we'll start with the 13th Amendment, which is the one that ends slavery. First, do you want to just say a few words to remind everyone of an overview of what that is before I get to a couple of specific questions about it from reading the book?
Yeah. The 13th Amendment was approved by Congress toward the end of the Civil War. Lincoln was still president. By the way, I noticed that somebody posted that today is Frederick Douglass's birthday.
Thank you, Joni.
If you know that, you know more than any other person in the country, because Frederick Douglass didn't know that what his birthday was as a slave. He always said, I don't know what day. Now, maybe he just chose February 14th as a nice day. We don't know exactly what Frederick Douglass's birthday was, but that's all right. Anyway, the 13th Amendment irrevocably abolished slavery. Now, someone may say, well, wait a minute. Why did they need the 13th Amendment? Didn't Lincoln free the slaves with the Emancipation Proclamation? Well, yes, on January 1st, 1863, Lincoln issued the Emancipation Proclamation, which declared free over 3 million slaves, over 3 million. But it did not apply to 750,000 who lived in the border states. There were 4 slave states that did not secede from the Union. They stayed in the Union. They didn't join the Confederacy: Maryland, Delaware, Kentucky, Missouri. The Emancipation Proclamation was a military measure against the Confederacy to weaken the Confederacy by eliminating slavery and enrolling Black men for the first time in the Union Army. But the border states were not part of the Confederacy. They were part of the Union. And Lincoln always felt he didn't have the constitutional right to attack slavery in the Union. The Confederacy had sort of abandoned their constitutional protections by trying to secede. So you needed something more than the Emancipation Proclamation that would irrevocably abolish slavery and would also eliminate the state. Slavery is created by state law. The federal government didn't create slavery. And there's nothing stopping a state from abolishing slavery. New York, New Jersey, all the northern states abolished slavery at some point. They could do that. But if they didn't, then state law would still protect slavery. So even the Emancipation Proclamation freeing large numbers of people didn't actually get at the laws that created slavery in the first time. But the 13th Amendment did. It just said slavery is abolished now, and it can never exist. It's a very sweeping measure. It's very brief. It sounds kind of almost matter of fact. But number one, what you are seeing here is just imagine this, the abrogation of the largest group of property, the largest concentration of property in the country is being abolished with no compensation to the owners. The slaves as property, the 4 million slaves, are worth more as property than all the banks, railroads, and factories in the United States put together. I don't know what, let's say today, the federal government just abolished Facebook, Microsoft, Apple, all these things, just said, no, these things no longer exist. And by the way, nobody who owns stock or anything in this is getting any compensation. That's just gone, folks. That would be a pretty disruptive thing in the economy, but this is what they did. The abolition of slavery with no compensation. Second of all, that amendment and the other two, 14 and 15, end with a section saying Congress shall have the right to enforce this amendment. Now, what does it mean to enforce the abolition of slavery? That is still being fought out in courts even today. The so-called legacy of slavery or the badges of slavery. Back in 1968 or 69, the Supreme Court upheld the open housing law, federal law barring discrimination in housing, rental sales, etc., on the basis of the 13th Amendment, saying this kind of discrimination is a badge of slavery. It's a continuation of some of the elements of slavery, and that gives the federal government the right under the 13th Amendment to act against it. But in fact, the 13th Amendment has rarely been used. Later, we may get to the Supreme Court and how they've totally screwed up interpreting these three amendments over the course of our history. But over time, the Supreme Court basically felt the 13th Amendment's aims have been accomplished. Slavery is gone. There's nothing more to be said. And many things which seem to have a connection to slavery, like mass incarceration of Black people, the court has said, well, that's not slavery. That's really a different question altogether. So, that is not, you can't attack that under the 13th Amendment. But nonetheless, this is a very dramatic shift. Interestingly, the 13th Amendment introduces the word slavery into the Constitution for the first time. The original Constitution protected slavery, no question about it, but it didn't refer to slaves or slavery. It spoke of other persons. It spoke of persons held to labor. The founders didn't want the word slavery in the Constitution, although they put the thing itself in there without any problem. Now, in the act of abolition, the word slavery is named, the institution is named in the US Constitution for the first time.
Right, and actually you led right into the next question that I was going to ask, which is, so we have, and you discussed at some length, the notion of that Section 2 allows the federal government to eliminate the badges and incidents of slavery. And on one level, and again, you discussed this in the book in considerable depth and eloquence, but it's obviously necessary, as even some defenders of slavery pointed out, if you're really going to eliminate slavery, you have to eliminate the badges and incidents of slavery. Otherwise, it's just a paper statement. But it's easy to see how a legalistic view, and I think we all get caught up nowadays in a very legalistic and limited view, would not even recognize badges and incidents. It would just say, well, you eliminate slavery, you eliminate that class of property. And so it's interesting that that sort of substantive interpretation that includes elimination of the badges and incidents, it's interesting to us who are accustomed to hearing about fairly legalistic interpretations of the Constitution, actually had a foothold, at least for a while, in the years after the Civil War. And I was intrigued by the fact that, as you mentioned, that the court went back to that on issues of housing as recently as the late 60s. Do you see the possibility of that again as an area that legal action and jurisprudence can continue to use?
Yeah, well, jurisprudence I've given up on. I'm afraid that the courts are just completely unredeemable in this country. The Supreme Court has been so wrong for so long about the 13th, 14th, and 15th Amendments that I don't see any hope for them. Maybe 5 new justices will pop up one of these days, but but the point is that actually the amendment says Congress shall have the power to enforce this. That's fairly clear. That they put that in for a reason. The reason was that Congress would keep an eye out about what was happening, and if they felt that some of the incidents of slavery were continuing, they could take action against it. They didn't just punt it to the courts and say, oh, well, let the courts handle this. They didn't even want the court. The Supreme Court at that time had completely surrendered whatever respect it may have had through the Dred Scott decision of 1857. Northerners thought that this was such a pro-slavery decision that it proved that the Supreme Court was worthless. They didn't want those guys determining what the meaning of the abolition of slavery was. In the debates in Congress, one congressman said, slavery is the sum of all villainies. It denies people the right to marry. It denies people the right to the fruits of their labor. It denies people the right to education, free speech. You name a right, and slavery deprives people of it. I don't see, there are people today trying to use the 13th Amendment to say, hey, wait a minute, these states like Mississippi are not providing actual education to their citizens, to students. They're getting terrible education. That is a badge of slavery. Slavery denied the right of Black people to get educated. It was against the law. Now they're not educating Black people again. They're not saying that, but they're giving a completely inadequate education. It's obvious if you go to Mississippi, that's what's happening. That should be challengeable under the 13th Amendment. Maybe it will be one of these days. I don't know. But, there are people trying to take an expansive view of the 13th Amendment, but they have always, with a few exceptions, been shot down by the Supreme Court. Even at the height of the so-called Warren Court in the late 60s, when that open housing decision was actually announced. But we're talking about the 14th. There are reasons why they chose that and not the 14th Amendment, which actually was more relevant, but they don't much like the 14th Amendment either. When it comes to race, on other things, the 14th Amendment has been used with tremendous value for the whole society.
So I was going to discuss the little clause in the 13th Amendment that says, except as a punishment for crime whereof the party shall have been duly convicted,
right.
and how that became the basis through its utter perversion for a whole history of convict labor in the South. But looking at the time, I think I'm going to skip that, and if we have time to come back to it later, I think it's a subject worthy of attention. And again, you do pay a fair amount of attention to that in the book, because I'd like to get on to the 14th. And the 14th, as you point out, is by far the longest amendment and has a number of provisions, including birthright citizenship, You want to say a few words about how distinctive that is and how that compares to other countries?
Yeah, well, the 14th is incredibly important in our history. It covers a myriad of subjects, some of which are kind of arcane, like it says nobody's going to get compensation for the loss of their slaves. Forget it. You're not, no one's going to pay you for that. Just going to face up to it. It says that if you loan money to the Confederacy, you're not getting it back. You bought Confederate bonds patriotically. That money is gone. Every once in a while, I get a call from someone or an email saying, you know, I got an old house, I'm remodeling it, and I found way in the attic these old Confederate bonds, you know, amazing. Are they worth anything? And I have to write back, well, I'm saying read Section 4 of the 14th Amendment. They're not worth anything, but they're rather colorful. I would put them in a frame and put them up on your wall, maybe as a decoration. The 14th Amendment is in the news right now, every day. We'll get to birthright citizenship. I have been promoting the use of, as others have, the use of the third section of the 14th Amendment, which is completely unknown. If before a month ago you had polled 100 law professors what is in the third section of the 14th Amendment, none of them would have known. Basically, what that section, that was to try to keep Confederates out of public office. And it says that anybody who took an oath to support the Constitution and then gave aid and comfort to the enemies of the Constitution is forever barred from holding public office. They didn't want guys who had held office before the Civil War, took an oath to support the Union, and then sided with the Confederates. They didn't want them back in office. Well, on January 7th, I woke up and I said, you know, this should apply to President Trump. He took an oath to support the Constitution. He encouraged, gave aid and comfort to the enemies of the Constitution yesterday when they assaulted the Capitol. So I wrote to a few people I know. And in fact, forget about impeachment. Impeachment's never going to get anywhere, as we see. This only requires a majority vote of Congress. It doesn't require 2/3. It's rarely been used, but it was used in a few cases in Reconstruction and a few other times where people were just barred from office, not put in jail, not fined, just said you can no longer hold office in this country. Anyway, that's the third section. Keep your eyes on it. Now that impeachment is over, it may pop up again. But the real core of the 14th Amendment is the first section, right, which, as you say, begins by stating birthright citizenship. Any person born in the United States and subject to the jurisdiction thereof is a citizen, both of the United States and of the state in which they live. Well, why is that important? First of all, remember, before the Civil War, the Dred Scott decision, the court had said, no Black person can be a citizen. Citizenship is just for white people. Black people can be here for generations, living here. They can never be American citizens. Well, this wipes away the Dred Scott decision. Anybody born here. Now, who are those people not subject to the jurisdiction in the United States? Those are Native Americans, who even still at that time were considered citizens of their own tribal sovereignty. They're a citizen of the Cherokee Nation or the Choctaw Nation or the Sioux Nation. The government deals with them by treaty and other ways, not through the normal law. But that's a small number, obviously, by then. But anybody else born in the United States is a citizen. It doesn't matter who your parents are. It doesn't matter where they came from. It doesn't matter what their race is, their religion. They're citizens. This is controversial today. There are people who want to get rid of that for the children of undocumented immigrants. A woman comes across the border. She's not a citizen. She doesn't become a citizen. And she has a child in the United States. What is the status of that child? The child's a citizen. That's what it says in the 14th Amendment. Now, President Trump, who's well known for his grasp of constitutional issues, he mused a couple of years ago that he could change this by executive order. He thought it was wrong that these people whose parents weren't citizens to become American citizens. He'd issue an order. Someone had to tell him, maybe Giuliani. Unfortunately, the president can't just change the Constitution by an executive order. President Trump said, really? Yeah, if someone convinced him he couldn't just change the whole Constitution. Because if he did, he'd probably get rid of the 13th Amendment too. But anyway, that's still in the Constitution, and it's very important. It's a statement that to be an American, you do not have to be of a certain race, of a certain religion, of a certain ethnic background, speak a certain language. Most countries in the world today do not have birthright citizenship. You can be born in France, and you're not automatically a citizen if your parents, let us say, are from Africa. You can become a citizen. You have to go through a whole process as if you're an immigrant, even though you were just born in France. Same thing, in fact, no country in Europe today has automatic birthright citizenship. It excludes people from certain, who got there in certain other ways. So it's a unique thing. Now, Latin American countries do have it. We're not the only one, but it's still a fairly rare thing in the world today. But it's a very important statement about what it is to be an American. Anybody can be a patriotic American. Doesn't matter where you came from, what your religion, race, whatever. That's only the first clause of the first section. It then goes on to introduce other things, but the key is no state can deny to any person, not just citizens, anybody who's here, the equal protection of the law. The 14th Amendment puts the word equal into the Constitution.
And before we get to the equal protection clause, I do want to look at the privileges or immunities clause, which comes before that.
Right.
States can't abridge the privileges or immunities of citizens. That is, of course, as again you say in great detail, that's eviscerated by the slaughterhouse cases. And I wonder if you could give us a little bit of the what was intended and what happened to the privileges and immunities, immunities clause.
When you say what was intended, you are opening up a giant can of worms. As you know, there is a whole jurisprudence based on original intent or original meaning. The problem is these amendments and laws of Reconstruction were passed after, well, there were compromises, there were changes in the language as it went along, they were ratified by different states in different times. There is no one single intent or meaning, even though there are members of the Supreme Court who try to, decide cases along those lines if they can. Privileges or immunity, nobody knows what that is. But the point is, again, Congress will enforce it. It's up to Congress to decide what are the privileges or immunities of American citizens. Is the right to vote a privilege? Well, no, not at this point. That distinction of the right to vote and other rights is still in existence. The 14th Amendment doesn't give anybody the right to vote. But what about the right to an education? Shouldn't that be a privilege of American citizens? Most people probably would say yes, but it isn't, according to the Supreme Court. They don't care. But, this had been debated in legal cases before the Civil War, but it was still a very vague and up in the air concept. But the main point is to link it to this equal. Whatever those privileges are, states cannot limit them by race. Equal protection. If the right to an education is something white people are going to get, then black people have to get it also. That's equal protection of the law. But the Supreme Court, as you said, in the early days of Reconstruction, in the 1870s, the court began to whittle away at these amendments. They felt that the changes in the Constitution had been too strong, too fast, and the first to go was privileges or immunities. In the slaughterhouse case, I'm not going to go into it, it's sort of complicated coming out of Louisiana, they basically said, look, yes, the 14th Amendment says everyone born here is a citizen of the United States and the state they're in. But the fact is that most of our rights still come from the states, not from the federal government. The Constitution hasn't really altered the balance between the states and the federal government. So people who sued in the Slaughterhouse case on the grounds that their national rights as citizens were being abridged, Supreme Court said, you don't really have any such rights, actually. All your rights come from the states. So go to state court. You can deal with this if you want, but there's no national power to enforce the rights of people in the states. That's a tremendous retreat from the idea of Reconstruction, that the federal government should be protecting the basic rights of the former slaves and indeed of other people in these states. The 14th Amendment, and indeed all three of these amendments, impose limitations on what the states can do. That's the first time. The original Constitution is all telling the federal government what it can't do. Like in the Bill of Rights, Congress shall make no law. First Amendment, barring freedom of speech, abridging freedom of speech. Let's say you try to give a speech against slavery in South Carolina before the Civil War. Can you do that? No. South Carolina said that's against the law. You can't give a speech against slavery. Well, what happened to the First Amendment? Freedom of speech, right? No, that has nothing to do with South Carolina. Congress shall make no law. That is restricting the national government, not the state governments. They can do anything they feel like. Massachusetts had an established church until the 1820s. Didn't that violate the First Amendment? No, that's Massachusetts. It's not a federal thing. But the Reconstruction Amendments bar the states from doing things. It's Congress that will now oversee the states. The danger to liberty comes from the states, not from the national government. Just the other day, the 14th Amendment is the gift that keeps on giving. It's always relevant. Just the other day, a federal court in Arkansas, of all places, overturned a state law which said that the state will not do business with any company that supports the movement to boycott Israel, okay? Now, whatever your view of boycotting Israel, the guys who are subject to this went to court and said, wait a minute, freedom of speech. The state can't tell me what political position I have to take in order to do business with the state. And the federal court there said, yeah, you're right, absolutely. Well, wait a minute. Didn't I say that the First Amendment only applied to Congress? This is a state law. But the 14th Amendment applies all that to the states. That's the concept we call incorporation. Now, over time, they did that. Now the states have to abide by the same civil liberties as the national government, thanks to the 14th Amendment. So Arkansas has to follow the First Amendment on freedom of speech because of the 14th Amendment. So this is a 14th Amendment case. And most of the really important 14th Amendment cases have been overturning state laws that violate the Bill of Rights or other kinds of rights that the 14th Amendment is supposed to protect. So for example, one man, one vote. States can't, screw up the boundaries of districts in order to have unequal political power in the state. 14th Amendment. Roe v. Wade, 14th Amendment. Most recently, gay marriage, 14th Amendment, equal protection. The state doesn't have to let people marry if it doesn't want to, but if it does, it can't say you can marry and you can't marry because we don't like those people. So we're not equal protection. States, not the federal government, have to now abide by, respect the principle of equal protection of all persons within their jurisprudence. So, one could go on and on with the 14th Amendment, but it really changes the whole relationship of individual Americans to the government, to the national government and the state governments. It makes the federal government, for the first time in our history, what Charles Sumner, the abolitionist senator, called the custodian of freedom. Federal government is not a danger to liberty, it is the custodian of liberty, thanks to the Reconstruction Amendments, or at least that's what it's supposed to be.
Right. And that, as you discuss in the book, has been an on and off thing over the 170 years since. Yeah. So the just want to very, very briefly touch on Section 2 of the 14th Amendment, which of course repeals the 3/5 clause, for one thing, by now saying that representation is by the number of people in the state. It is very controversial among at the time among women's suffrage advocates, because it introduces the word male for the first time. But perhaps for the present discussion, most interestingly, it provided for a reduction in legislative representation proportional to the fraction of male citizens who were denied or abridged their right to vote. And as you point out, that's virtually never been used. When I was doing a little side research, I came across the name of a congressman in the 1920s and 30s named George Tinkham from Massachusetts, who tried to actually use that against southern states and didn't get anywhere. Do you think it's conceivable that as we see efforts to suppress voting participation in various states in the country, that people could actually start to press Congress to start using Section 2 of the 14th Amendment? Or do you think
Absolutely.
That would be a pipe dream?
Before the third section came along, I was the president of an organization to enforce a committee to enforce the second section of the 14th Amendment. Now, this is a small group. There are only 2 members, me and Professor Gabriel Chin, a law professor at the University of California. We are advocates of enforcing. What does it say? Just to repeat, it says that it put the word male in, but that's now eliminated by the Women's Suffrage Amendment. So today, what it says is, if states deny any citizen the right to vote, except for commission of crime, so you have felony disenfranchisement seems to be allowed by it. Yeah. But if states deny any citizen the right to vote, they will lose representation in Congress in proportion. So like when this was passed, let us say Alabama was about half black and half white in their population. Congress gave them the choice in the 14th Amendment. You can either give black men the right to vote, that's cool, and keep all your representatives in Congress, or you can deny black men the right to vote, and then you're going to lose half your members of Congress, because that's half the voting population you're suddenly eliminating. This has never been enforced, never. There were efforts to do so. The NAACP in the 1910s, 20s, 30s tried to get Congress to enforce it. W.E.B. Du Bois, the great black scholar and activist, actually sent a petition to the United Nations asking them to see about enforcing it. At a time when, under the Jim Crow system, the vast majority of blacks in the South could not vote, Congress did nothing. The Supreme Court, they said, please don't bother us. We don't care about this. If white people want, Giles v. Harris, if white people want to take away the right to vote from blacks, that's their problem, not ours. So it was never enforced, but at the court level, never enforced. But I have done some calculations, and there are states today that have denied the right to vote to large numbers of people, thousands of people. Either they don't have the right ID, or their middle initial is wrong on one of their documents, or, you know, the registration. There are all sorts of voter suppression measures, as you know, that have been enacted in various states. It's not like Jim Crow, where half the population of a state couldn't vote. But there's enough that, in my calculation, Texas has denied enough people the right to vote that they should lose a couple of congressmen. How? I don't know. That's up to Congress to decide. Who? Which of their 30 some odd congressmen would be booted out? I don't know. But you know, it's an effort to encourage states to expand the right to vote, to protect the right to vote, not to eliminate or restrict it. However, underlying this is the point, which we sometimes don't even remember, that even today, there is no national right to vote in this country. There are 50 different legal systems about voting. You can move from New Jersey to, I don't know, Texas or Georgia and lose your right to vote because you don't have a proper kind of ID that they want or something like that. This is a weird country, 50 different systems of voting. And we saw that, you know, in November. One state allows, you know, mail-in voting. Another state doesn't allow mail-in voting. One says that absentee ballots get counted at the beginning. One says absentee ballots get counted at the end. You know, some states allow extra time for voting when there's a long line. Some states don't. In other words, there's no national set of qualifications. What there are a series of negative statements that states must abide by. The first being the 15th Amendment. A state cannot deny you the right to vote because of race. That's meant to guarantee Black men the right to vote. Okay, that's in the Constitution. Later on, 50 years later, a state cannot deny you the right to vote because of sex. Okay, now women will not be barred because of sex. Later on, 18-year-olds. Later on, poll tax. You cannot be denied the right to vote. There's a series of things that cannot be used to deny you the right to vote. But none of those say who does have the right to vote. And what about other qualifications? Under the Jim Crow system, Blacks were eliminated by grandfather clauses, by literacy tests, by property qualifications, by understanding clauses, where the register said, well, you got to explain the state constitution, and if you can't register to vote. It just so happened that all the white people seemed to know the state constitution and all the Black people somehow didn't. You know, so it's all these things are framed in the negative. There was, during Reconstruction, the radical Republicans said, no, we want an amendment which simply says every male citizen 21 years of age has the right to vote, period. Male, they would have insisted. They didn't favor women's suffrage at that time. That didn't get passed, unfortunately. It would have solved a lot of problems later on if a positive affirmation of everybody's right to vote had been put into the Constitution. But the reason it wasn't was that states want to control the right to vote. Not only southern states, northern states. California didn't want Chinese voting. They didn't even ratify the 15th Amendment, because nor did Oregon, because they thought that it would enfranchise Chinese immigrants over there. And Rhode Island had restrictions on immigrants of voting. So states wanted to control it. They gave Black men the right to vote, but they didn't want to go any further than that to affirm the right to vote.
So I actually have a long list of other points to discuss. I'm also looking at the time. So I just want to end with one, which was my last one. And I'm going to skip over. We could spend hours clearly discussing a lot of these issues. But this is a very fundamental one. Much of the thrust of what happens in the second founding, as you described it, and as you've just been speaking about, is the development of the notion that it's the national government, the federal government, which is the repository for Americans' rights and the source of protection at the origin of those rights, rather than the state government, at least as envisioned by these amendments. And that, of course, gives defenders of those rights the political tool, and I don't just mean in electoral politics, I mean in organizing and all the other ways, to pressure the federal government to actually enforce legislate the protection of those rights. One of the issues that raises, and in fact, the last section of each of those amendments is what almost becomes boilerplate in later amendments, that Congress shall have the right to enforce this amendment by appropriate legislation. So you see it in the 18th Amendment of all places, concurrent with the states. You see in the 19th, the 23rd, 24th, 26th. But here's a concern. These questions of rights then become national questions. And movements to secure these rights become movements to demand that the federal government enforce them. There's sort of an alternate or parallel vision here, which is that movements to enforce these rights also, some would say instead, but we know where that gets us, but at least also need to be locally and state-based, because otherwise you don't win the hearts and minds of the people. So, you know, you still have 70 million Trump voters who don't accept the number of the rights that are accepted there. And if you don't combine, and really I'm not talking about political activism, the guarantees at the national level with simultaneous and ongoing pressure at the local and state level, you're not necessarily going to have the permanence that you want. In other words, the question is the focus on the national guarantee of rights. Do you lose, or at least have the danger of losing, the necessity for parallel focus on local and state activism that's necessary? And this comes to mind, just to finish my sentence here. I'm reminded of Ruth Bader Ginsburg's critique of the tactics used to win Roe v. Wade, when she said, you know, great that we won this, but might have been even better if this had first been won, or at least concomitantly won, at the state and local level. So does this focus that these amendments give us on the national government have the danger of losing a certain value of the kind of local and state level organizing that's also needed? What are your thoughts on that?
Well, you know, first of all, we must not forget, obviously, there is a whole state. Every state has a constitution. Every state is supposed to enforce basic rights. This is not necessarily an either-or situation. Many of the advances lately have been under state constitutions, not the federal, since the Supreme Court and the general national government has abandoned enforcing the rights of Black people. States have stepped in to try to do that somewhat. You know, my view is whichever form of political authority is able to address all these issues of inequality should do it. I don't think but remember, the people who adopted these amendments, someone had put a question in about the Black codes. You know, I'm not going to give you the whole history of Reconstruction here in 2 minutes. And get the Barnes and Noble version, and you have it in there. But you know, after the Civil War was over, President Johnson, Andrew Johnson, who replaced Lincoln after Lincoln's death, and was until now considered the worst president in American history. I think he's been superseded, but certainly a contender. Johnson appointed these all-white governments in the South, which immediately passed what they call the Black Codes, which were laws basically to put Black people almost back into slavery. And Congress was outraged and passed, the 14th Amendment is partly inspired by what they saw happen in the Southern states. Refusal to accept the end of slavery, refusal to accept Black people having any rights, however you want to describe them. Insistence that they all go back to work on the plantations as if nothing had happened. That was state action. Who was going to stop that? Who was going to protect the former slaves? The country has abolished slavery. Well, people are still being held as slaves, you know? So the enhancement of the power of the federal government is a reaction against what happened at the state level once the White South was given a free hand by Andrew Johnson. Now later, Congress said, you know, these guys are so impossible. We're just getting rid of those governments altogether. And we're going to have new governments in the South with black men voting for the first time. And then you got these biracial governments and what they call radical Reconstruction, which only lasted about 10 years, but was an amazing experiment in interracial democracy. The first and one in the history of this country. But you know what? You're right. People prefer decisions to be made at the local level, and one of the many reasons for the decline of Reconstruction was many Northerners felt the power of the federal government had become too large. That was certainly what the Supreme Court did. The Supreme Court, all through the late 19th century, said federalism is still intact. Most of your rights come from the states. They kept striking down federal enforcement legislation because it enhanced the power of the national government over the states too much. The problem is, apart from that little period of Reconstruction, state governments in the South, both before that and then during the Jim Crow era, showed no concern whatsoever for recognizing the basic rights of Black people. If the federal government withdrew from doing that, well, then who was going to enforce these amendments? And in the end, they became dead letters for a long, long time until revived in a little after the middle of the 20th century.
Well, as I said, I could go on asking questions and posing questions. We have a few more minutes. Professor Foner has offered to stay with us until 12:30, and I certainly don't want to deprive him of the rest of his afternoon. So we have a few minutes for questions from people who are listening. If you have a question, raise your hand in the participant area. I'm not guaranteeing that I'm going to call on people in the order in which they raise their hands, because I know we have people we don't usually hear from who are here, and I'd like to make sure that we get a little bit of diversity. And I suspect we're going to have a lot of questions, so we're probably going to have time for just 2 or 3. That's in the nature of the beast when you have a really rich topic that needs to be discussed, and as I said, we could go on at greater length. So I will, however, I'll start with Peter. You're the first hand, so go ahead.
Thanks, Dan, and thank you, Dan and Eric. Wonderful discussion. I mean, this is really relevant, and it could go on. And it's amazing to me how the Black codes have morphed to today's world. And I just wanted to ask Eric if he saw the Black codes, these catch-22s, still in existence today.
Well, the Black codes, as I say, were enacted at the end of 1865, beginning of 1866, by these all-white governments in the South created by Andrew Johnson. They were a kind of catch-22. They had to say, slaves are free now. There's no more slavery in our states. The 13th Amendment is part of the Constitution. And they recognized a few rights of African Americans, primarily the right to marry, because under slavery, slaves' marriages were not legally recognized, even though they did have families, of course. But the main point was to force them, they passed every adult Black person has to sign a labor contract to work for a white employer for the year. And if they don't do that, they're going to be arrested, fined, and sold off to work for someone who will pay their fine for the course of the year. Black people say, hey, they're putting us back into slavery again here. And Northerners were outraged by this. And very quickly, those laws were overturned. The Freedmen's Bureau, which was there as a federal agency trying to assist in the transition from slavery to freedom, invalidated a lot of these laws. And then the 14th Amendment basically said that these laws can't exist. You can't have laws just for Black people. Equal protection of the laws means the law has to apply to everybody. You can't have Black codes and white codes. But so it's not the enforcement of these Black codes, but what they represented about what the mind of the white South was in the aftermath of the Civil War, and what fate would be in store for the emancipated slaves unless the federal government intervened. So that's the real, I think, significance of these Black Code laws.
Thanks. I see we have a question from Hallie Bravetti. Hallie is a resident of Teaneck here and is a guest attending. Hallie, can you unmute yourself? And by the way, it says Hallie. I'm assuming that's you, but it may be your husband Vince if he's using your name. Can you unmute yourself, and whichever of you it is, ask your question?
Sure, yeah, this is actually Hallie, the daughter of Hallie and Vincent. So nice
okay.
to meet you, Dan. It's really, I'm happy to be here. Thank you, Eric, for all your time with us today.
Yeah, thank you.
I apologize, yeah, if I missed this earlier, but can you go a little bit into the third section of the 14th Amendment and just exactly what the steps Congress could take, for example, against our former president's actions at the Capitol? Like what would that look like?
Third section. Third
section, that's correct, right?
You know, this has been enforced very rarely. It was enforced, and in different ways. At one point during Reconstruction, Congress ordered local district attorneys to remove any official in the South who violated the third section. If there was, and several judges were removed from the bench in Tennessee. These were guys who had, it's not just your ordinary Confederate soldier. These are people who had held an office before the war. In other words, they had taken an oath to support the Constitution and then supported the Confederacy. Congress just said, well, this is now the Constitution. Local DAs should remove these guys, and some of them did. They also passed joint resolutions saying, hey, so-and-so in Mississippi is holding an office and he's not entitled anymore. This was done in 1918. I think the last time this was enforced was against Victor Berger, a socialist elected to Congress at that time from Milwaukee, Wisconsin, who was tried and convicted under the Espionage Act because he opposed American participation in World War I, sorry.
Yeah.
And when he was convicted, the House said he's violated Section 3 because he gave aid and comfort to the enemies of the Constitution, so he's out. They kicked him out of Congress. Then the Supreme Court overturned his conviction, and he was let back in, and he served several more years in Congress. But so in 1918, Congress still thought that Section 3 was viable, so to speak. How this would be done, I have no idea. It doesn't require a whole trial like impeachment. It might require just a congressional hearing where somebody says, well, Mr. Trump here took an oath to support the Constitution, and then he gave aid to a rioting mob and all this and encouraged them, and therefore he's not eligible anymore. That's just what the 14th Amendment says. He's no longer eligible for office. So Congress maybe would pass a joint resolution or something saying this fellow is violated the third section. Let us imagine, this is hard to imagine. Let us imagine that AOC, Alexandria Ocasio-Cortez, somehow wanted to run for president and got herself nominated and on the ballot. Somebody would come along and say, you know, she's not 35 years old. She doesn't meet the qualifications. She can't be president because the qualification for office includes being 35 years of age. And so somebody, the court, somebody will say, I'm sorry, you can't run. Very nice to meet you, but you don't meet the qualification. Same thing could happen here. Somebody goes, well, wait a minute, this guy is trying to run for office, and yet he gave aid and comfort to the enemies of the Constitution, so he should not be allowed to run. It's just a qualification for office, you know? I don't know. They'd have to figure out a way of doing it, but it is in there, in the Constitution for a purpose. Otherwise, it's a dead letter.
Great, thank you.
Hello.
So I see that it's 12:30.
Right.
I see there are two more questions. Professor Foner, would you be willing to hang on for a few more
Yeah,
minutes? Or do you have...
well, one more question, because I do have to, this is.
May I ask?
Okay, hold on. We can't just have people who haven't raised their hands asking. We have people who have raised their hands, and so I'm going to ask, it's a toss-up. Pamela, go ahead.
This is Carol. Who was Jim Crow?
Who was Jim Crow?
No, Carol.
No,
Carol,
I'm sorry, Carol.
Carol, I said I can't just have people who haven't raised their hands ask questions.
I'm on the telephone.
She's on the phone.
Yeah, I know.
Jim Crow was a character in minstrel shows before the Civil War. Blackface minstrel shows.
Okay. And, Pamela, go ahead. and that will be it.
Thank you very, very much, Eric. This was exciting, wonderful. My question is, with all the things that have gone on in the past few months in Congress and with President Trump, can people be kicked out of Congress for what they say? Because you can impeach a president, but what right or what power does the government have to impeach a congresswoman or congressman? Like,
I don't know. I should go back to I don't think it's impeachment exactly, but the Constitution says each house is the judge of the qualifications of its own members. And people have been expelled from both the House and the Senate over time for various infractions of one kind or another. And that would probably be the route if someone were going to be expelled. I mean, if, Preston Brooks was expelled because he beat up Charles Sumner, the senator, on the floor of the Senate in 1856. He'd been expelled for various other infractions. But it doesn't seem likely that that's going to happen. Whether a member of Congress could be impeached, I don't know. I'm not a lawyer. I'm not a law professor. I'd have to go back and see exactly what the Constitution says about this. But anyway, I want to thank everybody for listening and coming. I'm very happy to talk to you. And thanks to Daniel for moderating and asking me. I'm sorry if my answers went too long and didn't give enough time for people, but that's how I operate. I start talking and I can't stop. But anyway, if you want to learn more about this, you can easily pick up my book, paperback. It's pretty cheap. And if you do it through Barnes & Noble, you get the appendix too. So,
Eric, if you'll forgive me for switching to first names just for a moment.
Yeah.
I'm reminded, I once heard Irving Howe give a talk, and this was when I was a graduate student. He actually gave a talk at one of the Reform synagogues in the suburb south of Pittsburgh.
Right.
And he said, there are three Jewish diseases. He said, there's tuberculosis, there's diabetes, and there's lecturing. And he said, tuberculosis can be cured, diabetes can be controlled, but lecturing can be neither cured nor controlled. And then he went off and gave a great lecture.
Yeah, I'm sure. I'm sure that. Yeah.
So I'm well acquainted with the with the problem. It's not a problem. This was an extraordinarily informative discussion, and I'm sure everyone else has been participating.
Okay. Well, thank you all very much. And
thank you very much.
Okay.
Be
Bye-bye.
well. Happy Valentine's Day, and thanks very much again.